to stay out of my head. Stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do they make it for time that I've lost? Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed the payments on purpose. Can you see I failed and I'm hurting? Ain't had no job, so no working. Or the job I work is not working.
This is your ARC. Y'all is magnified, coming back with another informative video. I titled this video, Conclusion of the Matter. Osiris client, federal lawsuit, part 4. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, let's get to it. Okay guys, I call this video the conclusion of the matter because I already went through 3 parts of this person's case. Okay, we covered it from the beginning all the way to the end. So if you all want to know the outcome of your situation, if you was to file in federal court, go back and watch part 1 of this video. Okay, I will put the link in the description box so you guys can go back from the beginning and watch all 3 series that led up to this final conclusion. Okay, so now let's pick this up at the top. As you know, it's in the United States District Court for the Northern District of Georgia Atlanta Division, right? Then we have, again, Destin Gerd Daniels, of the family Daniels. Whenever you see that of the family, we already know who involved with it. Let's continue. And he was the plaintiff. That he was going against Henry County, Georgia. Okay? My author hit me up in my email saying, excuse me, not in my email, but hit me up in YouTube. He was stating that he's suing the county, so I'm pretty sure who's helping him. You know, this obviously is the same person that's helping this man right here. So for the brother that was in my YouTube comments telling me that you was suing the county, 9 times out of 10 this will be your results. Okay, so I'm just giving you a heads up early. So let's get more information, more understanding. Okay, it's time to apply that pressure, man. Like I tell you all, man, stay out of these federal courts because nothing good is coming out of those federal courts. Let's continue. It states, this case comes before the court on defendant's motion for summary judgment. After due consideration, the courts enter the following orders. So this is what? The defendant's summary judgment. Who is the defendant again? The defendant is Henry County. Okay? Let's continue. Background. Plaintiff, Destin Gerd Daniels, proceeding pro se, filed suit against defendant Henry County on January 11, 2018, alleging violations of his 1st, 4th, 5th, 6th, 13th, and 14th Amendment rights. See docket number 1. Plaintiff claims that Henry County and the Georgia Department of Human Services Division of Child Support Services, DCSS, conspired against plaintiff by enforcing his child support payments and collecting his personal information without his consent in violation of his constitutional rights. Plaintiff seeks termination of his child support case, a refund of prior child support payments, payment of DCSS federal profits from its collection of child support payments and penalties and interest. On June 21, 2018, the court issued an order on defendants and former defendants DCSS motion to dismiss. See docket number 22. The court dismissed plaintiff's claim against DCSS for insufficient process and further held that 1. Plaintiff claims against Henry County were barred by what? Sovereign immunity. Okay? I keep telling you guys, the county has sovereign immunity. The agency has sovereign immunity. Why? Because all of these are arms of the state. Okay? So for the person keep telling y'all to go into these courts and bring these governmental entities or these arms of the states or the states in the federal court, you will lose every time. But let's continue. Henry County is not liable for the acts or omissions by Henry County's courts. And 3, plaintiff punitive damages claims was barred because punitive damages are not recoverable against a county for state law or 1983 claims. You see? So we know who keep telling y'all to file these 1983 claims. I tell y'all, man, the fraud of law, he know what he's doing. All his clients are receiving the same results. Okay, but what he's trying to do is make you guys believe something that is not true. And I keep telling y'all, that stuff is not true. It do not work. It never will. It never has been. I know. I was his client once. I tried it. It don't work. You know, it didn't work for me. It didn't work for nobody else. Let's continue. However, the court denied Henry County's motion to dismiss as it relates to plaintiff's remaining federal claims, specifically that defendant infringed upon his constitutional rights by enforcing his child support obligations, and that defendant violated his due process rights by requiring him to acknowledge paternity. CID, defendant now moves for summary judgment on plaintiff's remaining federal claims. So now this is Henry County motion for summary judgment on the remaining federal claims that was brought up against Henry County. So let's continue. Legal standards. Federal Civil Procedure 56 provides the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material facts and the movement is entitled to judgment as a matter of law. Federal Rules of Civil Procedures 56A. A factual dispute is genuine if the evidence would allow a reasonable jury to find for the non-moving party. Right? Let's continue. Case law to support that. 1986. A fact is material if it is a legal element of the claims under the applicable substantive law which might affect the outcome of the case. Case law to support that. Then it states the moving party bears the initial burden of showing the court by reference of material and records that there is no genuine dispute as to any material facts that should be decided at a trial. Okay, so let's continue. The moving party's burden is discharged merely by showing that point out the district court that there is an absence of evidence to support an essential element of the non-movement party cases. Case law to support that. Then it says in determining whether the moving party has met this burden, the district court must view the evidence and all factual inferences in light most favorable to the party opposing the motion, which would be Osiris' client. But let's continue. Once the moving party has adequately supported its motion, the non-movement then has the burden of showing that summary judgment is improper by coming forward with specific facts showing a genuine dispute. Case law to support that. Now the whole thing is that his client come up with a genuine dispute to dispute the summary judgment that the defendant applied for, which is Henry County. Let's continue. There is no genuine dispute for trial when the record as a whole could not lead a rational tier of fact to find for the non-moving party. Then it says citations omitted. Then it says all reasonable doubts, however, are resolved in favor of the non-moving party. Okay, let's continue. While courts show leniency to pro se litigants not enjoyed by counsel litigants, this leniency does not permit a court to serve as de facto counsel for a party or to overlook deficiencies in their filings. Case law to support that. Further, a pro se litigant does not escape the essential burden under summary judgment standards of establishing that there is a genuine issue as to a fact material to his case in order to avert summary judgment. Okay? Case law to support that. Decision. Now this is the decision, guys. It states, as a primary matter, Local Rule 56B2 requires a party opposing a motion for summary judgment to submit a response to a movement's statement of undisputed material facts. Plaintiffs produced such a response but failed to include relevant citations to support his facts or objections to plaintiff's statements of undisputed material facts. You see what I mean? So when the guy writes up the paperwork, he basically don't know how to write up a claim. What he do is write up a bunch of allegations and make it seem as though they're claims, okay? One of the allegations he got a lot of people believing is that child support is not an arm of the state when all the case laws say it. So they're going to automatically rule against you for that one reason alone if you don't address that issue properly. And you don't, so you shouldn't be in the federal courts, period. I keep telling people that, but let's continue. Under this court, local rules, that failure has consequences indeed. This court will deem each of the moving facts as omitted unless the respondent, 1. Directly refutes the moving facts with concise responses supported by specific citations to evidence, including page or paragraph numbers. 2. States a valid objection to the admissibility of the moving facts. Or 3. Points out that the moving citation does not support the moving facts, or that the moving facts is not material or otherwise has failed to comply with such provisions set out in LR 56 1B1. Okay, so he's basically telling them what must be done in order to what rebut the summary judgment, which the county put the facts in the summary judgment. You know, so why you saying that the county is not an arm of the state, or why you saying that the county did all these violations of your constitutional rights? If you don't have many factual evidence to support that, then you're going to lose. Let's continue. Defendant's statement of undisputed facts which are not controverted are deemed admitted, pursuant to local rules. Then it says, while the court notes plaintiff's pro se status, that does not permit courts to overlook deficiencies in plaintiff's filings. Additionally, although a court will literally construe pro se pleadings, pro se litigants are still required to conform to procedural rules. Case law to support that. Because plaintiff has failed to comply with his court local rules, the court deems plaintiff's undisputed statements of material facts admitted. You see what I mean? So basically saying the person that's calling himself the God of law don't know anything at all. You see? He don't even know how to rebut the presumptions. But let's continue. Turning now to defendant's motion for summary judgment, defendant argues that plaintiff claims are barred by statute of limitations. In Georgia, the statute of limitations for 1983 claims is 2 years. Case law to support that. Here, plaintiff claim stems from a paternity acknowledgement, the acknowledgement that he signed when he was 18 years old, docket number 56-1. The acknowledgement authorized DCSS to have the Henry County Superior Court issue a contempt order requiring plaintiff to pay child support. Thus, plaintiff claim arose between October 29, 2007 and October 28, 2008 when he signed the acknowledgement of paternity. Right? Or did it, well, they actually say when he signed the acknowledgement, but let's continue. Given the 2-year statute of limitation on subsection 1983 claims, the latest plaintiff could have brought the instant action was October 28, 2010. Because plaintiff filed this action on January 11, 2018, his claims are barred by statute of limitations. Even if the statute of limitations did not bar plaintiff's claims, defendant is nevertheless entitled to summary judgment for 2 primary reasons. First, plaintiff seeks to hold defendant liable for Henry County Superior Court's enforcement of his child support obligations based on the contractual alleged executed between the defendant and DCSS. DCSS pursuant to 42 U.S.C. subsection 654. So now, how many brothers are going to court right now, filing their lawsuits in this federal court underneath 42 U.S.C. 654? How many? A lot of you guys are. Let's continue. However, plaintiff has not provided any evidence that such contract exists. See docket number 1, right? Then it says, instead, plaintiff has produced screenshots of DCSS website indicating that DCSS has an office located in Henry County, right? Docket number 58. Then it says, while the evidence of the non-movement is to be believed and all justifiable inferences are to be drawn in his favor, evidence that DCSS has an office in Henry County is not evidence that the defendant entered into a contract with DCSS. Case law to support that. Then it says, accordingly, plaintiff has failed to demonstrate a genuine issue of material facts as to the alleged contract and therefore provides no means by which to hold Henry County liable for the alleged constitutional violations. Second, plaintiff due process claims fail because the undisputed facts demonstrated that he voluntarily signed the acknowledgement. Plaintiff alleges that Henry County violated his due process when he failed to inform him that he did not have to sign the acknowledgement. But the acknowledgement that plaintiff has produced shows that he was notified of his voluntary nature. Specifically, the acknowledgement lists 7 bullet points explaining the rights and responsibilities of individuals signing the acknowledgement. The first bullet point under the rights and responsibility heading explicitly states that signing the paternity acknowledgement is strictly voluntary. Having been on notice of the voluntary nature of the acknowledgement, plaintiff cannot now argue that his signing of the acknowledgement constitutes a violation of due process. Thus, as there is no genuine dispute of material facts remaining for trial, defendant's motion for summary judgment is granted. Okay, so again, I can't stress this enough, guys. You know, another one bites the dust. So he lost all 3. Everything he brought to the court, all was dismissed. Every single last one of them, okay? Every last one of them. So for this person to keep calling himself the God of law, but he have no victories, then something's wrong here, man. Something is wrong, you know. But let's continue. Conclusion. For the above stated reasons, defendant motion for summary judgment is hereby granted, as there are no further issues outstanding. The clerk is directed to close this case. It is ordered. Now the case is closed. First day of July 2019. But let's finish reading this right here. Section 654 provides a means by which states can enter into cooperative agreements with appropriate courts to assist in administering plans for child and spousal support. 42 U.S.C. subsection 654-7. However, plaintiff offers no authority for his proposition that Section 654 is applicable to this case, or that the statute in any way obligates the well-established rule that under Georgia law, counties are not liable for the acts or omissions of the county's courts, because counties have no power to authorize, no powers or authorities over such courts, right? Then it says, finding that the court cannot be held liable for a judge pro temporis actions, because a judge pro temporis is an officer of the state. You see? So if the judge is an officer of the state, that means what? The judge, if he's acting in his scope of duty, falls under what? Sovereign immunity. So for the people that's suing these judges, the people that's suing the county, for the people that's suing the agencies, for the people that's suing the agents, all in federal court, you're getting the same results. Why? Because they have this thing covered. If you want to fight them, beat them in state court. That's where your remedy lies. That's why I keep showing y'all. Every time I put up a testimony of some sort, it's dealing with the state alone. It's not dealing with the federal court. No one has ever won a federal lawsuit. Okay? Not even, I don't know why the fraud of law keep telling you guys to do these things. But we know that the fact will be the fact, the truth will be the truth. He cannot show you evidence of these things. And because he can't show you evidence of these things, then it's not so. That's what I keep trying to tell you guys. So that's all I'm going to do for today. If you all